Bienvenue. Hi, everybody. Welcome back to Ottawa. I hope everybody enjoyed a set of quality moments with friends and family over the course of the holiday. We're certainly being greeted with some winter weather, although I do want to note for the record for all of those from Ontario and other parts of the country complaining, my partner sent me a note yesterday to show that it was minus 51 with the wind in Winnipeg. So unless where you come from is worse than that, thanks for your understanding about how us Manitobans feel. This is a retreat, is it not, Ted? Indeed. So, colleagues, we are here today for the first hour. Something that's a little bit out of the ordinary in the course of our normal affairs, but ordinary within the affairs of Parliament as a whole. That is that I received a letter from the chair of the Finance Committee to ask for our assistance, which she has done with many other committees, to reduce the load that they have to undertake in the evaluation of the BIA, the Budget Implementation Act. Common practice just in order for efficiency within the process at committee. So, pursuant to that standing order, today we have an evaluation of an act to implement certain provisions of the budget, in particular relevant to our committee, clauses 389 to 398. Division 23, clauses 589 to 591, Division 39, and clauses 597 and 598, Division 43. So we will have two guests with us today, followed by Minister Joly and her officials who will be here next week. That was the ask from the Finance Committee. So we are fulfilling that in today's meeting and in Monday's meeting, assuming the schedule goes according to plan. So joining us today are Philippe Dufresne, who is Canada's Privacy Commissioner, as well as Marc Chenier, the Deputy Commissioner and Senior General Counsel. They will speak to their responsibilities within the BIA and why they're here today. And then there will be an opportunity, as always, for members to speak. I am going to hold us to time today, so we are going to end exactly at the 1 hour mark because we have things to get to in the form of a draft report and a couple of other items of business. With that, Mr. Dufresne, I pass the mic to you. The floor is yours for upwards of 5 minutes, sir. Thank you.
Merci, Monsieur le Président. Merci pour l'invitation.
Thank you, Mr. Chair, and thank you for the invitation to appear before you today to offer my views on the privacy implications of Part 5, Division 23 of Bill C-15, the Budget 2025 Implementation Act No. 1. Privacy is an important and timely issue for Canada. As more and more personal data is being collected, used, and shared, data protection becomes increasingly significant for Canadians and Canadian organizations.
We've seen many examples of how Canadian privacy law can address major issues that cause serious and long-lasting harms to individuals. For example, protecting against the non-consensual sharing of intimate images in my investigation into ALO, which operates Pornhub and other pornographic websites, and addressing the 23andMe breach, which impacted the highly sensitive personal information of 7 million customers, including more than 300,000 Canadians. My recent investigation with my provincial counterparts into TikTok, meanwhile, highlighted the importance of protecting children's privacy in today's online world. The impact of our investigation in this widely used platform went far beyond a report. It also enabled the company to implement improvements to its privacy practices in the best interest of its users, especially children. I recently announced an expanded investigation into the social media platform X and its Grok chatbot. This investigation will examine the emerging phenomenon of AI being used to create deepfakes, which can present significant risks to Canadians. Ce sont là quelques-uns des nombreux exemples qui démontrent.
These are some of the many examples that demonstrate the importance of privacy for current and future generations. These examples also illustrate how prioritizing privacy is a strategic and competitive asset for organizations. This is why it's so important to modernize legislation so that we have modern laws in place to support businesses in ensuring that they have appropriate protections.
Embedding data protection into programs and services can enable responsible innovation, facilitate global operations, improve data security, and mitigate risks, including of major breaches. Modernizing privacy laws aligns with Canada's ambition to support growth, to seek opportunities with partners around the world, and to continue to be a voice of modern progress, setting the stage for a safe and secure digital future for Canadians and Canadian industry. Le projet de loi C-15 comprend des articles.
Bill C-15 includes sections that would amend the Personal Information Protection and Electronics Documents Act, or PIPEDA, to provide a right to data mobility to facilitate information sharing across all economic sectors. I support efforts to introduce such right to data mobility in Canada. A right to data mobility would give Canadians greater control of their personal information by allowing them to make decisions about who they want their information shared with. This would also make it easier for them to switch service providers and choose with which organizations they wish to engage. These are important considerations for building trust in today's digital economy.
Mobility provisions can also support economic growth in Canada. For example, it would help promote competition and innovation by allowing individuals to take advantage of new business models like consumer-driven banking and encourage new players in the market, therefore helping to support small and medium-sized organizations. Specifically, Bill C-15 would add a new Division 1.2 to PIPEDA that would require an organization upon an individual's request to disclose the personal information that it has collected from them to a designated organization. This right would be subject to regulations and would only apply if both organizations are subject to a data mobility framework. Bill C-15 would amend PIPEDA to provide the Governor and Council with the authority to make regulations regarding data mobility frameworks. These regulations would cover key aspects of a mobility framework, including safeguards and technical parameters for ensuring interoperability. They would also specify which organizations are subject to a framework and provide for exceptions to the requirement to disclose information. Compte tenu de l'ampleur des questions qui seront.
Given the extent of issues to be prescribed by regulation, it will be important for my office to be consulted by the government in the development of these regulations. I certainly look forward to working with the government on these important issues. Thank you. I would be happy to answer any questions that you may have. Thank you very much.
Enter into our line of questioning. Mr. Guglielmin, the floor is yours for 6 minutes.
Thank you, Chair. Thank you for your testimony, Commissioner. In Section 10.4 of Bill C-15's Division 23, so this proposed data mobility framework, it's intended to grow out of regulation. In other words, it'll be bureaucrats, not parliamentarians, who have oversight over its development. Do you believe that this introduces transparency concerns around the way in which Canadian data is handled?
Well, I believe that my office should be consulted in the development of those regulations, and that's why I'm setting out my expectation here, and as I did in the other place when I appeared to discuss this. I think that the legislation provides for the frameworks and the important topics and safeguards and parameters and specifying organizations and exceptions. And so my role in this, and I will be reaching out to the government to make sure that, and I expect this to not be an issue, that my office be consulted.
Do you think that transparency might be enhanced by amending the legislation to allow for provisions of the data mobility framework to be statutorily established?
That's a decision for Parliament to make. Certainly, there is always a balance between having elements in legislation, more debate and more parliamentary accountability. Some elements in regulation allows faster development, more adaptation. And so it's up to Parliament to strike the right balance. In this instance, I do not have concerns with the way it is provided. However, this is based on my expectation that the government will consult with my office in the drafting.
Do you think that the overall transparency and potentially the efficacy of the legislation could be strengthened by requiring the regulations that are governing the data mobility framework to be published before they come into force, perhaps?
Publishing before coming into force and consulting with industry and consulting with the regulator. I think the more we do those things, the more awareness industry and Canadians have, and so they can prepare for the implementation and they can provide their feedback.
So what do you think are the chief challenges with developing this framework through regulation outside of the immediate focus of the Canadian public?
Well, I think the challenge is in making sure that you have something that will work for Canadians, work for industry, that it allows key elements, and we see some of that in the bill in terms of consumer banking, in terms of consent, in terms of safeguarding, in terms of making sure that if there is a privacy breach, that is reported quickly to the authorities, to the regulator. There's a big element of role for the Bank of Canada in terms of the banking sector to approve entities and to report breaches. And I think it's going to be important for the Bank of Canada and my office and other affected entities and regulators to work together. And I look forward to doing that.
Thank you, Commissioner. I'm going to switch over to, in your testimony, you were talking about deep fakes. Now, the government's introduced legislation, Bill C-16. It's intended to criminalize the creation of and distribution of intimate deep fakes. At the same time, we have experts like Susie Dunn, Assistant Professor of Law at the University of Dalhousie, who have warned the bill's definition of deepfake may be too narrow to capture much of the harmful content currently circulating online. That includes platforms like X. As the committee prepares to undertake a study on artificial intelligence more broadly, what recommendations would you offer us to ensure that legislation more effectively protects Canadians' privacy and potentially provides meaningful recourse for victims that have already experienced non-consensual AI intimate images?
Well, my overall recommendation is to modernize PIPEDA, modernize private sector privacy legislation. That is a mandate of this committee. That is an area where Minister for AI has said publicly that the government looks to introduce at some point modernized legislation. There were attempts in the past. And my main message is we need to modernize and we need to give my office enforcement authorities. This is a major gap in the enforcement regime where I can only issue recommendations. I cannot issue orders and I cannot issue fines. And we are standing out amongst international partners in this respect. So that is an easy fix that Parliament can do. There are other elements that need to be modernized as well. But that would give me the enhanced tools that I need. In the meantime, I have been and will continue to use the existing tools to deal with those issues. That's what I did in dealing with Pornhub. That's what I am doing in dealing with the investigation of X and the deepfakes. But the fact remains that I cannot issue orders at the end of those investigations.
So I understand that XAI has recently indicated it'll geo-block content where it violates laws of a particular jurisdiction. However, there are many who would argue that that response comes after significant harm has already occurred and that victims of intimate deepfakes continue to live with the consequences long after content is removed or restricted. So simply from a privacy and victim protection perspective, what's it say about the adequacy of current regulatory approaches that often rely on reactive enforcement rather than preventative safeguards?
Well, certainly, I won't say too much in terms of X because I've launched my investigation last week. We're going to proceed swiftly on it, and we're going to use the tools, and we're going to draw our conclusions on it. I think the challenge, if I look to our concluded investigation of Pornhub on a similar related issue of online-based abuse and sharing intimate videos without the consent of individuals in the context of revenge porn and other types of situations, we investigated. We made a finding that this breached privacy law. We made strong recommendations that there needed to be a solution from now on, forward-looking. But what do you do with what has already been posted? So we wanted this to also be taken down. We wanted the takedown mechanisms to be faster, to be user-friendly. The company refused to do that. And now we are in federal court trying to enforce this, but it is slow and expensive. And in the meantime, those images continue to be available. So that's where amending PIPEDA and giving my office order-making powers and the ability to issue or recommend fines would have a much more immediate remedy, which could then be challenged in front of the court. So that's the challenge. You're often going to have responsive complaints or proactive complaints in the context of Grok. I initiated it myself. But what's important is that once those are concluded, you get a real and meaningful remedy if there's been a violation.
Thank you.
Thanks very much, Mr. Guglielmin. Mr. Baines, the floor is yours for 6 minutes.
Thank you, Mr. Chair, and thank you, Commissioner, for joining us today. My first question to you is, how will the government ensure that regulatory requirements for data mobility do not disproportionately burden small and medium enterprises?
Well, I think that is an important part of any new law or rule or regulation that the government adopts. It's important to hear from industry. It's important that the department hear from industry. It's important that industry itself be able to make its concerns and its realities known, in particular small and medium enterprise. And so that's, from my standpoint as a regulator, I also need and want to know what are the challenges of industry, what are the hurdles, because it's regulation to be effective. It has to be practical. It has to be doable by small and medium enterprises. It, of course, has to protect Canadians. And that's why building privacy at the outset, making sure that we have good frameworks, good involvement of the regulator, good dialogue with industry, it allows industry to build this in from the beginning. It's more effective, it's less expensive, and it leads to more trust from consumers. And this is going to be key, in my view, in terms of data mobility, in terms of consumer banking. Canadians need to trust this, and they will trust it if they can see that privacy is built in from the start.
Thank you. And with respect to monetary penalties, I have a question. You appeared before the Senate Committee on Banking, Commerce, Productivity, where you stated that you do not currently have the authority to impose financial consequences for a breach of liability. So in your view, is a monetary penalty one of the most effective ways to ensure compliance, or do you have other ways that you would go about it when dealing with breaches of sensitive information?
Well, I believe that we need to use all of the tools at our disposal. So the financial penalties, the orders, the enforcement, that should always be a last resort. We should always try to prevent and resolve and educate and work together. So that's what we're doing at my office. So I'm trying to resolve things quickly, informally, with letters of engagements, with commitments, with compliance agreements. However, in situation where there is a disagreement or there's a major violation, you need that capability to enforce. And you also, I would argue, need the possibility of fines to help decision makers and CEOs and boards and investors to invest the necessary sums to protect privacy. If there's the risk of financial consequences, it gives arguments to the privacy champions in those organizations to build those protection for Canadians. So it serves everyone in the end. I want the ability to issue fines. I hope to rarely, if ever, have to issue them. But the existence of that possibility will make it easier for my office to convince organizations to prevent and to take the necessary steps.
Okay, and part of the committee's responsibility is to establish recommendations. So maybe if you could provide in your, a set of recommendations that, with respect to data mobility safeguards that need to be put in place. How can data mobility, how can we put those in place? How can Canadians feel secure that their information and data isn't going to be exposed when it is shared?
Well, in terms of the recommendations, we've highlighted a number of priority recommendations for law reform, which I think are relevant in the context of what do you do to protect the mobility of Canadians. So you need to make sure that there is strong enforcement if there is noncompliance. You need to make sure that there is the proper assessment, whether it's a privacy impact assessment or privacy by design, making sure that you bring this at the forefront. And there are good elements of that in Bill C-15 in terms of consumer-based banking, in terms of making the consent express and user-friendly. These are things that we always recommend and want to see. Things like preventing, identifying privacy breaches. This is a major challenge to society all over the world, not just in Canada. And we're seeing them increase, where they're increasing in number, they're increasing in magnitude. I talked about the 23andMe major breach that I investigated with my counterpart from the UK. Very sensitive genetic information, hundreds of thousands of individuals impacted. So we need to work on that. This also costs money to organizations. So it's bad for everyone. And so the regulations need to provide for good safeguards, good reporting mechanisms in the consumer-based banking. They're talking about immediately advising the entity responsible. So we need to do all of those things. And there needs to be good and strong collaboration between regulators when there's potential overlap, as there would be here. So I look forward to working with the Bank of Canada, as I am working already with the Competition Bureau and CRTC. Digital issues and mobility issues don't stop at the border of one regulator or even one jurisdiction. So that collaboration is essential.
Can you expand on that, some of the other departmental needs that we have to work with? So you talked about CRTC and others. So is the information sharing between the different departments, does that need more improvement? If you can just sort of expand on how that's working.
And just quickly, Mr. Commissioner, thank you.
Information between departments is an issue that would also fall under the public sector privacy law, and that also needs to be amended. Departments need to be able to share information amongst each other. If it's personal information, there should be safeguards, but departments should talk to one another when they're dealing with breaches, because that helps prevention and it helps remedying it.
Si j'ai oublié de mentionner au début, juste
I forgot to mention at the outset, and I just want to make sure.
for interpreting earpiece, that it's on the sticker in front of you to protect the well-being of our interpreters here, parce que je sais qu'on va probablement, je suis presque...
Because I'm aware that we will very likely continue in French. Mr. Sainte-Marie, you have 6 minutes. Yes, thank you, Mr. Chair, and good day to all colleagues, and a hello to the new colleagues among us, and a special hello to our witnesses, Mr. Fresne and Mr. Chenier. Thank you, Mr. Dufresne, for your presentation. A good deal of information in the answers you've provided us with so far. I will get into a couple of different topics here in my questions. Let me begin with the part of C15 that deals with the open banking or open financial system. If you were to look at that, what would you have to say to us about the responsibilities of the various players when it comes to data breaches? I think that the bill has a few good elements in it requiring immediate notification. That's very positive. In my legislation covering the protection of personal information in the private sector, we did already suggest that that be strengthened, that it be specified in less than 7 days, 7 work days, but now I think it says immediate, something like that, which is very positive. It also brings up the matter of situations in which the Bank of Canada or other organizations would be involved. I might receive a warning or a notification because these entities as well would have to respect the private information framework. So this is something I have been suggesting for quite some time now, that regulatory organizations should be in a position to share information among them when this sharing is in support of their mandates. It's also a matter of departments sometimes being victims of breaches, and sometimes it takes quite a bit of time before the various organizations are able to speak across barriers. So this is very important. It's very good to have it in the bill. Thank you very much. Another topic, once again, data mobility, being able to authorize the transfer of one's personal data from one institution to another, especially federally regulated institutions. But there might be provincially regulated businesses or organizations. From your point of view, has the government consulted with its similar groups in the provinces to improve a seamless approach? And are the organizations, let's say in Quebec, ready to work using this new approach? When it comes to consultation between the various levels of governments and across departments, I can't give you that information because that's not what I'm working on, but I would assume so. I'd be very surprised to hear that there hadn't been consultation between the levels of government, across ministries, departments. It certainly has been the case that we've had very close relationships with the people who do our sort of work in Quebec, at least out of my office. Very important because there are a number of issues that affect both levels. Quebec has its own regulations about mobility, portability, if you wish, of personal data, and we took that into account in drawing up the federal law. There can be a number of organizations under provincial jurisdiction that might wish to make use of the framework we're suggesting. So I think it would be possible for us to recognize provincial jurisdiction entities to be included in this framework. But it'll be important for organizations and organizers to ensure that there's proper interoperability up and running with the provinces, including Quebec. Thank you very much. Another topic. You referred to this in your presentation and in answering a question put by one of my colleagues. So in the legislation, the part at issue for us, there's a lot that's left to future regulations. For us, as MPs, we are basically counting on the government because we don't vote on regulations in the House. You say that you take it for granted that the government will consult you as it draws up these regulations. But I would just like to validate with you, has the government undertaken to do so, or is it that written into C-15 that they will consult you and that you'll have a hand to play in the making of the regulations? It's not obligatory under the bill that we be consulted. Among other nations that have such legislation, that's not necessarily the case. You don't necessarily state in legislation that you're going to include the Privacy Commissioner in drawing up your legislation. Australia has done this. That's an exception. It's not necessarily the case, though. I have said publicly in my testimony before the Senate as well, I've also said it in other contexts, and I tell the government when I do interact with them that consultations like that are useful to everyone. Avoiding situations that could become difficult. For example, ultimately, I work for you, and if you ask me, were you consulted, and I have to say no, that raises a number of eyebrows. So I tell the government, look, this will work for everyone. We're here for you, and the Parliament could specify that it is obligatory if it so wishes. What I do is lay out my expectations. I'll continue to do so. If it's not in the legislation per se, and the government doesn't do it, then I will make my concerns known in my annual report and so forth, but I'm optimistic that they will consult me. So despite your optimism, so far, every time you've brought this issue up, the government has never undertaken, systematically that is, to include you in its making of regulations. I've not heard them say no either. I haven't necessarily got, a black on white, yes, we will definitely consult you, but I don't hear the opposite either. I must say that in the context of the potential legislative reforms to PIPEDA, we have so far had very good interactions with the department, with the upper echelons of the department, so I think that things will continue to go well. Thank you very much. Thank you, Mr. Simard.
Just for 5 minutes.
Thank you, Commissioners, for being here today. Appreciate you answering our questions. The new data mobility, is mine on? Okay. The new data mobility framework is meant to make it easier for people to switch services and increase competition. There isn't an outline on how this will work, and details like which industries are included, what data can be transferred, or how it will be protected. And who is responsible if something goes wrong will be decided later by the government. It'll be important for your office to be consulted by the government in the development of those regulations. Do you have faith that you actually will be consulted?
Well, as I was indicated to your colleague, Mr. Sainte-Marie, I am optimistic. I'm setting out publicly my expectations. I've done this in the other place, and I'm doing it here. There is precedent, I would say, from the standpoint where the Parliament amended the legislation on financial crimes and the FinTrack to allow more personal-to-personal information being shared by banks within each other to identify fraud and terrorism financing, and this led to the creation of a code of practice regime that is reviewed by my office and approved by my office. So there is a precedent for positive, constructive exchanges. I'm optimistic that it's going to happen, but I will certainly monitor it. If it does not happen, you will hear from me on it, because I think it would be a disservice to the institutions, to the industry, and ultimately to Canadians.
Thank you, sir. We are seeing more and more attacks, more and more we're hearing about more and more hacking, and consumers are just left on their own to fight for themselves with maybe a sorry. So loss of financial data has far more dramatic effects on people's lives, especially if it gets into the wrong hands of criminals. So when the breaches happen, what are the penalties, or what should be the penalties for those who do the breaching?
Well, when we look at breaches, we're always looking at what measures were put in place, what should have been put in place, what are the lessons learned, and was there inappropriate care with the personal information of Canadians, given the sensitivity, given the risk, given the attractiveness. Right now, there are no penalties, and that's the concern. In Canadian privacy law, there are no penalties at all. And this becomes evident when we compare ourselves to other regulators, including within Canada. Quebec now has the ability to issue fines, my counterparts in Quebec, but internationally as well. So when I investigated 23andMe, the massive breach of genetic data, my UK counterpart issued a major fine on the organization, because this was a situation where there had significant shortcomings and it led to terrible harms on individuals. You're absolutely right that we should not be treating this as a technical matter. This harms real people in a real significant way, sometimes forever. It's difficult to chase that information. So there needs to be strong enforcement and strong consequences in appropriate cases. At the same time, we also need to help and work with industry. It's challenging. There are bad actors, and they're using AI and fast-evolving technology. So it's something that we all have to work together, but that gap in enforcement makes us weaker in that respect, and I think this is something that can and should be changed.
Okay, so the system for sharing data outside of Canada, as you say, is not as rigorous as it should be. Do you believe we need stronger legislation in that regard?
Well, sharing data outside of Canada is an area of my recommended amendments to privacy legislation. Right now, we have a general sense that if you're sharing data outside, you have to make sure by contracts or other means that you have an equivalent level of protection. But this could be more robust. There are other jurisdictions which will call on a review of the entire legal system of where it's going, to say, is there rule of law there? It's always a concern, government access to private data, because you can't have a contract that's going to prevent another government from taking information. So we need to strengthen that.
For another question, these things happen really fast. Data mobility produces real-time risks. Is a complaints-based model sufficient for this kind of program, or can we do better?
Well, it's not sufficient, and that's why we need multiple tools. So my preference is to do proactive action, to do education, to have frameworks, to have good regulation that is going to help industry do what's necessary, to have quick reporting if there's a breach, to have early compliance letters. I dealt with a big breach of Power School of information, and we got the organization to commit very quickly early on to fixing it without the need for a long investigation. You're going to need investigation in some cases, but it's a spectrum of tools. I agree with you that we should not be, certainly not always reactively. We have to try to anticipate those things, prevent those things, create that culture of privacy, work with the good actors, but for the bad actors, we need more enforcement.
Thank you very much, Ms. Borelli. Mr. Bardizzi, the floor is yours for 5 minutes.
Thank you so much, Chair. A lot of important roles for your office in this legislation and these amendments. Do you feel you have the sufficient resources to be able to be responsive to the possibility of more public requests for your office to get involved in these issues?
Well, we're monitoring all of the potential new roles. In this instance, in this legislation, I'm setting out the need to be consulted in the regulations and to be working closely with the other entities. So that I would not anticipate that to require much more resources. But overall, we do have resource concerns at the OPC. We are in a time, as you know, of restraint, of departments are reducing their resources. We are in a situation where privacy challenges are growing, where the impacts of technology, the impacts of breach, all of those things are growing. So that would be more my concern in terms of making sure that even in a period of budgetary reduction, we be mindful of the context of privacy where breaches is a new mandate. We have that as an increase. And we are seeing the technology evolve and the data uses increase. So there's opportunities for Canadians. We're going to continue to monitor the situation to make sure we can deliver.
You referred to the data uses increasing, and I think one of the things that is concern probably to all of us in this House and in this committee is the growing prospects for data use, but getting ahead of Canadians' understanding of what their abilities, for instance, even to be protected by this legislation are. They may not have the awareness of it, or they may not be familiar with what frameworks might actually protect them and which ones they could actually freely contract into. Could you just speak to your understanding of Canadians' literacy on data protection frameworks and what we might need to do to elevate that literacy?
We certainly need to elevate it, and we're seeing in our surveys increasing concerns from Canadians. 9 in 10 Canadians concerned about their data, their privacy, a sense that things are moving quickly. Parents concerned that their kids will not know how to protect themselves and their personal information. So we need to do more. I'm working together closely with the community here in Canada and around the world. Recently, we issued with the provincial colleagues and territorial colleagues a resolution on EdTech and making sure what are our expectations in terms of the use of EdTech, making sure that this is top of mind in the best interest of the child, and making sure that parents and kids have a good understanding. And a lot of kids do. We've just created a youth council at my office. I meet with youth to understand their perspectives. But they do feel that they're being surveilled. And they're very knowledgeable, sometimes more than we think, about the technology. But they do feel this sense that they're being asked for information and that it's challenging for them. So we need more of that. And it's something that will require the whole community in Canada and internationally as well.
To have sovereign data or to protect Canadian personal data within Canada depends on companies and markets that are sufficiently competitive so that you have options available in Canada, or so that especially public sector institutions that might have limited resources can freely contract with entities that are able to provide that protection in Canada, but also at an affordable price. Do you have any perspectives on that particular question as it stands right now?
Well, I think the question of data sovereignty is a very important one, as is the question of competition and access. And so I think this is an area that the government and Parliament needs to reflect on, in particular in the context of privacy legislation. So I've recommended that one of the strengthening be on the cross-border data transfer. It's one of those areas of tension where, on the one hand, you need to protect data sovereignty and make sure that things that shouldn't leave jurisdiction don't leave the jurisdiction. On the other hand, strong economies and international trade will require data transfers between jurisdictions, and that requires a good framework around that. And so that's why one of my priorities is to focus on that and to make sure we can have data-free flow with trust, and that Canadians have better awareness, more transparency on that. And the decision on TikTok, one of our specific recommendations was to make it much more clear, and the organization agreed about the fact that the data of Canadians could leave the jurisdiction. Where is it going, and what are the implications? People need to know that.
Thank you.
Thanks, Mr. Pardisi. Monsieur Saint-Marie, 2 minutes 30 secondes.
Oui, merci, Monsieur le Président.
Yes, thank you, Mr. Chair. Let me go back to the case that has been mentioned about banks and technological companies being under provincial law. What happens when there is not any link between the federal and provincial governments. My concern is that the companies that are not covered by both legislations, are sort of ping-ponged about, and the consumer pays the price. That's why it's so important to ensure that departments speak to each other regarding regulations and regarding the sector. And I can tell you this because I've had discussion with industry representatives and attorneys that represent them. It's a question put not only within Canada but also in other countries. There are a number of jurisdictions around the world asking, well, what are we doing? And what we do is work closely with them. We try to say, look, here's what we all have in common, and sometimes we even carry out joint investigations, as we did regarding TikTok with our colleagues from the provinces. This is to help the companies. We tell them, look, you'll only have to answer our questions once. But of course, if there is insufficient integration, insufficient interoperability, people could say, well, look, I'll take, this set of legislation rather than the other because it works better for me. And that's not as good for consumers. When it comes to privacy, though, I say if there are two sets of legislation that apply, the sector should respect the most demanding set of laws, because that way they'll be sure to respect both of them, but that's not necessarily something they all agree with. Thank you so much. Given that my time is nearly over, Mr. Chair, I will stop here in order to respect your timekeeping. Very kind, because I gave you 45 seconds extra last time, so thanks for giving it back, Mr. Saint-Marie.
Thank you, sir.
Okay, thank you, Mr. Chair. Thank you to our witnesses. You've provided some very valuable information. I have a German Shepherd dog that does investigations very quickly and issues his report swiftly, and he has the ability to escalate. You're telling me you're missing the ability to escalate. You issue reports. What happens?
Well, that's right. So I issue a report and I make recommendations if there's been an infringement of legislation. And we work with the respondents to say, we want to bring you into compliance. So here is what we think you should do. And in many cases, I'm happy to say, in many cases, the organizations will agree to our recommendations. They'll implement it, and then we can say this was well-founded and resolved, or conditionally resolved. That's the goal, unless it's not well-founded. And that even happened in the TikTok investigation, where they agreed to all of our recommendations. So that's a good news story. But in some cases, there is no agreement, like in the Pornhub investigation, where the organization refused to require the express consent of all individuals whose intimate images are posted, and refused to have a takedown mechanism that was at the level that we felt would be user-friendly and quick enough. So then we have to take the matter to federal court. And it's different from an appeal. We have to prove the case from the beginning. So we have to starting from scratch. And then the federal court will make its decision, has there been a breach or not? And then it can be appealed all the way to the Supreme Court of Canada. So that brings significant costs and delays to everyone, my office, individuals affected, and industry. And it delays the outcome. And in the case of Pornhub, it means that there is no immediate enforceability of the order. If we had the ability to issue an order, the order would be made, and then the information would be taken down. There could be an appeal afterwards. Of course, our decisions may be overturned. But in the meantime, Canadians would be protected. So it would be the most protective approach. Right now, we do not have that, and it's a gap.
And you would say a significant enough gap that it should be addressed?
Absolutely, it should be addressed. We are standing out in the international community by not having this. And I'm grateful for the many times that organizations are going to agree to the recommendations, and that's a testament to them. But as a legal regime, having something that is so important to privacy, that's so important to individuals, that's so important to businesses, I would argue, part of Canadian values and necessary to freedom and democracy, to have it not enforceable is a concern, and is something that should be fixed quickly.
So your mandate in this legislation is being expanded, but you're not giving the tools to really do the job?
Well, right now there's no bill. It's expanded in this context.
Yes.
It's expanded in this context from the standpoint that now there's going to be data mobility. But you are correct. I have no greater enforcement power as a result of this than I did before.
So your enforcement, would that mean you always have to press legal charges? Do you go through through the authorities to do that? Or do you go to a minister to report and say charges need to be pressed here? Or what is the process?
Thank you. No, I'm fully independent from the minister. So as an agent of parliament, I would report to you and to the House and to the Senate. So I do not need that, but I would need to take action in court, file applications in federal court with all of the necessary legal expenses that entails. So I become a bit of like a prosecutor at that stage.
So in the case of Pornhub, where you found significant breaches,
right.
Law enforcement didn't pick up the torch and assign you a prosecutor that did the work for you?
No, we're doing that ourselves. So I have lawyers representing me in court as we speak, and we're moving this forward. We're continuing to try to convince the organization to adopt our recommendations. But if this fails, the only avenue is to pursue the court matter to the end.
Okay. Inside this legislation, there's also a provision that gives ministers to waive laws without proper disclosure. What are I'm sure you have concerns.
Right. Well, this is
about 30 seconds, Commissioner, if you can.
Yeah. So this is meant to allow testing and testing of technology and innovation and giving that suspension of legislation. So we see this in certain regime in terms of having sandboxes. This is also very much an area where I would like to see regulator involvement. In many regimes, we see the regulators, my equivalents, involved in that, participate in those sandboxes and be there to say, okay, we have concerns, we don't have concerns. That's not present in this current form.
Okay. Thank you, Mr. Falk. Mr. Ma, the floor is yours for 5 minutes.
Thank you, gentlemen, for being here. My first question is, does this legislation mandate data be resided in Canada as a first measure? And then with the case of data mobility, will there be explicit consent by the consumer and exactly where the data will be resided so that they're open to know exactly where the data is going?
There is no requirement that it be residing in Canada. So that is not something that is required here. It's something that could be added through regulations, and it's something that I believe Parliament should be reflecting on in the context of privacy legislation overall. I don't think that you can have an absolute requirement that nothing leaves Canada from a trade standpoint. That would significantly limit innovation and trade, but there's certain areas where there's national security or otherwise where there is need for greater rigor. And so that issue is very important. In terms of express consent, with respect to the open banking part of the legislation, that is there, that is necessary, and indeed there's good language in terms of having it understandable for consumers. In terms of the more general provision, this is something that would be in regulation, so something that I look forward to seeing developed, and has certainly been a key part of our recommendations and advice that we give in terms of privacy. Canadians need to understand what's going to happen. They need to be able to agree. Otherwise, they're not going to buy in, and the system's not going to succeed.
And on that topic of data mobility, are there regulations now then, or in the proposed legislation, having data be encrypted in either residency as well as in transit, so that the data is always protected?
These would also be, I believe, aspects that are going to be defined in the regulation in terms of the extent of the safeguarding, the types of requirements that you want to see. And so this is, again, an area where you want to have the right balance in terms of not making it too onerous for organizations, but at the same time, and depending on the sensitivity of information, the more sensitive the information is, the stronger the safeguards should be. And so this has been a theme in our work dealing with privacy breaches. The more risk, the more consequences, the more safeguards. And it's important to get that right. And we've, in fact, developed, to help, in particular, SMEs, we've developed an online tool where individuals can provide us with a description of what happened in terms of a breach, and it will give them a tentative sense of, is this serious enough to warrant notification to the regulator? So to help them, because it's not always easy when you're in this situation. I think something similar could be done in the context of the regulation.
Okay. We know in a lot of websites, and including corporate requirements, they tend to ask a lot of questions beyond the business transactions they're involved with. Is there now legislation to mandate you could only allow to collect data that is relevant to that transaction?
Well, that's one of the principles of private sector privacy legislation in terms of appropriate purposes, not going more than what you need. I think there's a specific example of this in the open banking legislation in terms of prohibition of what's called screen scraping, where it indicates you cannot use, for the purpose of providing a consumer in Canada with a product or service, use an interface or application to gain direct access to their data using their authentication. So this would be an example where you have that information for the purpose of authentication. You shouldn't use it for another purpose. And that's a good practice overall. If you want to use it for something different that's beyond the reasonable expectations of individuals, then you should seek that separate consent or make it clear in your policies.
Well, in fact, I do have experience in the screen scraping over 20 years ago. The challenge there is that when the open banking allows this type of activity, it exposes especially the seniors to more risks. Because right now, if they're exposed to one banking account, that's the limitation. But once you get into open banking, they could now, or the criminals can now access more than just a single account. What provision is being put in to actually help protect that from further exploitation?
Well, I would point to the provisions on express consent in the open banking, talking about how it's important that this be done, that this be understandable, and looking at there too, there will be some specific regulations, and I think this is a great example of something that we need to get right. We often, in a lot of our work, for example, we're going to be in Supreme Court in March on a case against Facebook, where a big disagreement that we have is how clear is the consent provision? How clear is the privacy policy? Often, they're very complex. They're very complex even for lawyers and experts, let alone individuals who are busy and who are not experts in the field. So we need to do better across the board on this, in my view, but particularly, as you point out, for seniors, also for children. And so in TikTok, we actually recommended specifically that the policies for children be described in a different way. And some of our own statements that we've done with the province on privacy of young people, we've published them with a sort of more user-friendly way. And I think that's always a good exercise.
So back to the beginning, you talked about
Mr. Ma, I'm sorry to cut you off,
okay.
but we're a little bit over
I'm
time.
so excited. So.
Yeah, okay, well, appreciate the testimony. All right, thank you, sir, for being here. Thank you to you both. Colleagues, we're going to move to our in-camera round in a moment. I will break, although I did want to, while we are in public, unfortunately some very sad news I just received that our former colleague, Member of Parliament Kirsty Duncan, has passed away. Many of you worked with Kirsty over the course of the past number of years. She's a former minister responsible for science and innovation and was a wonderful individual with a great spirit. So while we were together here publicly, I wanted to share that. Certainly sad for colleagues in the Liberal Party, but beyond that, sad for all parliamentarians when we lose someone with whom we served or who served the country. So I just wanted to take a moment to send condolences to Kirsty's family and to thank them for, as we know, is a debt of gratitude that is owed for the time that loved ones spend away from their family to serve the country, and certainly at a time of loss, it's important to recognize how precious that time is. So wanted to share that before we temporarily break, and we will come back here in a few moments to pick up on the rest of the business. So suspended. Thank you, colleagues.
you.